Good evening. The final session today. This session, as you know, is about the phone hacking Murdoch empire crumble story. And we regret that Nick Davies couldn't join us today, which he was interested to do. His daughter's being graduating in York or someplace, so he couldn't be with us. But we have a very good panel of people to discuss three aspects of it. David Leigh, of course, from The Guardian, who can tell us exactly how the story has evolved and the mechanics of the story and what's been involved in it. And Gavin Millar, QC, on the legal, and Jeff Katz on the security and private investigating and telephone technology part of what I hope will be an interesting argument. Even though everybody seems to have the same view, I think it's slightly disturbing. But I think we'll start there. David, if you'd like to start.
Okay, well, this has been a tumultuous week, and I've been absolutely breathless trying to work out what to say, because every time I switch on the TV or the radio, somebody else has resigned. And in between parking the car and coming in here, I see that Rupert Murdoch announced he was going to make personal apologies to everybody he's done bad by, which would be a long period.
Many years.
Back over many years, yes, all the way back probably to Michael Foote, who his paper's accused of being a KGB agent, and Adolf Hitler, I suppose, whose fake diaries he ran in the Sunday Times some years ago. This summer school is designed to be educational, I guess. So I thought that what I would do very briefly is just sketch out what I think the issues for investigative journalism are that are going to come up out of all this. When we have this judicial inquiry, which is promised, it scares me a little, because the terms of reference are defined as being an inquiry into the press, the practices of the press. Now, I don't like that, because I think it should be an inquiry pretty exclusively into the practices of the tabloid press. And I think what ought to come out of it would be some kind of inquiry into depiction of the landscape of and guidelines about the use of private detectives. Because at the back of a lot of this, there has been the private BIC. And it seems to me that the newspaper landscape in Britain divides into three, really. The first group are the quality papers, I would say the Telegraph, the Financial Times, my own paper, The Guardian, where I'm investigations editor, for those of you who don't know. I think we very rarely use unorthodox methods, very rarely use private detectives, very rarely cross the boundaries of the law. Very rarely isn't the same as never. The Telegraph, for example, as I'm sure you all know, paid large sums of money to buy stolen documents in order to expose MPs' expenses. And I think most of you, or all of you, would probably agree it was a good thing to do in the end. You know, on The Guardian, people have, on rare occasions, done unorthodox things. I myself, as I wrote at the time of the news of the world hacking, I once looked at a pile of rather stinky material tipped in front of me by Benji the bin man, who used to rifle through lawyers' abandoned rubbish in the city. And it seemed like a worthwhile thing for me to do at the time.
Yeah, he's a friend of mine, actually, so you can be careful about that.
Benji's
a close friend of mine.
Well, he was a close friend of mine, actually. And the reason I was doing that, well, the same reason the Telegraph was doing what it did, was that we believed that what we were doing was rare, carefully considered and controlled, and completely in the public interest, because we were trying to expose serious wrongdoing. So that's the first group of papers, right, who occasionally use these methods. The second group, I would have said, is papers of the type of the Sunday Times, who is another one in the beleaguered Murdoch stable, of course, who, they play dirtier than me. They're more ruthless and unscrupulous than I'm comfortable with personally. But when they use private detectives, which they have been doing for, I would have said, at least the last dozen years, absolutely regularly and routinely, it's always been in pursuit of some kind of public interest justification. You know, they've been trying to get into people's bank accounts, they've been blagging information, they enraged Gordon Brown by employing a con man to wheedle information about his house purchase because they had an idea he'd bought a house at a knockdown price. All that kind of thing is justifiable if you're pursuing public interest stories. A question for the judicial inquiry is going to be, where do you draw the line in that kind of activity so that there are some guidelines about what is okay to do, what is not okay to do. And the third group, and that's the one that's caused all the trouble, is the tabloids, the News of the World mainly, the other tabloids too, and they haven't had, it's not so much they've drawn ethical guidelines in the wrong place, they haven't had any guidelines at all. They've run amok, they've used the things that private dicks can do in the service of, as we all now discover, you know, preying on the innocent victims of crime, hacking Millie Dowler's phone, prurently intruding into people's private lives and their sexual lives and their medical lives, merely to sell a few papers in a sort of completely amoral landscape. And there, I don't think we need a judicial inquiry to draw the line. We need what I hope we're going to get. We need a clean-up of the stables. We need, as well as these resignations, we need some arrests. And we need some people to be put in jail. So that's the sort of landscape that I think the judicial inquiry is going to be treading across. And I'm a little bit worried about how it's going to end up. That's it.
Okay. Jeff.
Well, as a representative, in some ways, I suppose, self-appointed in this case, of the investigative world, I suppose I should be, you know, wearing a hair shirt and generally beating my chest. But like David, I would draw some distinctions within the investigative world. I would say there are probably 4 types of investigators, and really it's 2 groups that themselves divide into 2. There is what I would refer to as the corporate investigation world, which tends to work for large organizations and businesses, which is what my organization does, by and large. And within that group of corporate investigators, there's probably a division. Those people who try very hard to stay on the right side of the line most of the time, and those who aren't particularly bothered one way or the other. And you know, if the money waved in front of them is big enough, will do whatever they're asked to do, or whatever they think they need to do to earn that money. And then the second group, which divides similarly, are the small individual private investigators, most of them, you know, ex-police or ex-military people, who have gone into work as private investigators. And again, you find a division there between those who are very ethical in what they do, very concerned about being seen on the right side of the line, and those who really don't care very much one way or the other. I would probably stick Lynn McCare in the second group of the second group. But there is that divide, and I think it's worth noting. I think what I would like to do is tell you a bit about, about what I think the investigator's view is, but also maybe a little bit about lifetimes and the universe in relation to this issue. So I'm going to outline very quickly and then go back a little bit. I would say, first of all, in terms of behavior of investigators, I have to say that in 24 years of working in corporate investigations, I've never instructed anyone to hack a phone, and I've never been asked to hack a phone. It's an activity that's clearly against the Regulation of Investigatory Powers Act, so it is clearly a criminal offense. And most professional investigators wouldn't do it simply because of the risk to their reputations. You do it once, you get caught, you're finished. So most investigators, in fact, won't do it. That's not to say nobody will do it. Now, a slightly more philosophical observation, I think that our society is actually quite schizophrenic when it comes to issues of law and ethical behavior. You know, we pass laws, often in the light of some gross misconduct, and then we either ignore them or enforce them only when it's inconvenient not to. The Collins Dictionary definition of corrupt says it means lacking in integrity, open to or involving bribery or other dishonest practices. Now, on the one hand, we pass laws against corruption, and on the other hand, we try to impede them. The Speaker of the House, when he tried to exempt MPs' expenses from the Freedom of Information Act, or the Blair government when it stopped the SFO investigation into the BAE bribery of Saudi officials. So we fool ourselves that because we pass laws, we've taken a stand against unethical behavior, but law is an imperfect method of governing human conduct, and that's why it constantly changes. And then I think it's worth talking a bit about the media and society. Anyone who read my bio in the speaker's site, the website, knows that I actually spent about 15 years as a journalist before I went into investigations. Now, in that time, the best definition I ever heard of news was from a newspaper proprietor and editor from whom I worked here in the UK, and he said, news is whatever an editor says it is. And what I like about that definition is that it places the responsibility for the content of a paper right where it belongs, with the editor. And if a newspaper decides to produce stories on the basis of phone hacking or any other unethical behavior, it's because the editor explicitly or implicitly has made it clear that's what he or she expects. Now, just going back to that point a little bit about the media, as I say, media values are dependent upon the editor. The editor will define news according to the expectations of his employer and his readership. Now, I think an editor can actually, to some extent, shape his readership, but he can't shape his publisher. The American commentator A.J. Liebling said, freedom of the press is guaranteed only to those who own one. Now, if a journalist wants to work on a newspaper, he has to accept the values of that newspaper. In the case of the tabloid press, those values have been defined by scandals that ideally combine sex, money, and politics, but mostly sex. Many journalists enter the trade because they want to do serious investigations. Unfortunately, investigations are a very small part of print and broadcast journalism. Very few newspapers employ specifically investigative journalists. My last experience of full-time journalism was back in 1987, and it ended when the daily newspaper I was working for here in the UK refused to publish an investigative series I'd written about nuclear submarines. I'd been hired to do investigative work, but I crossed a line that the editor could not accept. His news values were based on the very conservative environment of the locality and the owner of his paper. In my investigations career, I've often been approached by journalists looking for assistance with stories when they're trying to identify possible sources, but I have been asked to obtain personal information only once in 24 years. The character of a newspaper, the nature of its coverage, will generally determine the behavior of its staff. If the editor wants to maintain a stream of revelations about the lives of celebrities or about ordinary people who happen to be in the spotlight, then he will expect his staff to produce the stories and may not care about how they do it. I think it's worth noting that so far there's only one investigator in the hacking saga that we've all been hearing about, but there are about 10 journalists. I suspect there'll be more people from both trades who get pulled into the story, but the majority will be journalists because one investigator can feed many journalists. I don't think we'll find that the hacking was restricted to News International. The journalistic community is fluid. I would be surprised that the same practices did not exist at Trinity Mirror and associated newspapers. Finally, the press does not exist in isolation from society. We live in a surveillance culture. It is inevitable that what can be done will be done. The issue is to try to keep those activities that we prefer to minimize from becoming institutionalized. Those are my thoughts about the media. Now, a slightly broader thought. Our society is also schizophrenic about many of its attitudes. There is public outrage because it's been discovered that ordinary people have been victims to phone hacking by a private investigator hired by a newspaper. However, through our government and our taxes, we maintain a facility that costs more than £1.5 billion to build, that employs 5,500 people at an average salary of £44,000 per year each, and maintains hundreds of consultancy contracts, each of which costs an average of more than £100,000. This facility is called GCHQ. Its primary purpose is to intercept telephone calls, email messages, fax messages, and other forms of communications. We excuse this on the grounds that it is mandated in our name for national security. So in the name of national security, we enable our government to spy on private individuals who the government decides, in secret, to be acceptable as victims for spying. Now, I'm not making a judgment here about whether we should or shouldn't have GCHQ. I'm simply pointing out that the qualitative difference between the two situations is that the hacking scandal was discoverable. And in the process of that discovery, things were revealed which had a strong emotional component. We know that a great deal more institutional spying goes on, but we don't object. Firstly, because we can't. There's no mechanism by which we can do so. And secondly, because we don't know what there may be to object to. We're also schizophrenic about our attitude toward the law. Our parliament passes laws against corruption in the belief that it will somehow define the parameters of what is acceptable in our society. Then we find that the lawmakers themselves steal money from the public purse by manipulating their expenses. We find that when the public prosecutors identify a massive case of corruption in the form of BAE's payments to Saudi officials, the government decides it is inconvenient for political, diplomatic, and economic reasons to prosecute the matter. Perhaps the most interesting example is a slightly older one, that of Clive Ponting, a Ministry of Defense civil servant who was prosecuted in 1985 for giving secret documents to an MP. The documents showed that the government had lied about the sinking of an Argentine battleship during the Falklands War, that the ship had been retreating from the scene and was outside the exclusion zone when it was sunk by British fire. Ponting was prosecuted under the Official Secrets Act. He admitted the offense, but was found not guilty, even though the judge had told the jury that, and I'm quoting here, the public interest is what the government of the day says it is. The judge's statement was then enshrined in law by a conservative government in 1989 in their revision of the Official Secrets Act. Now, these are significant indications to me of a society that says one thing and does something else. So it should not be surprising if such confused values invade every aspect of our lives. And finally, a little bit more about investigators. Hacking is a clear breach, as I said, of the Regulation of Investigatory Powers Act. While we don't actually know if the journalists who initiated the hacking knew they were breaking the law, our common sense tells us that the extent and nature of the hacking was not constructively in the public interest. It may have satisfied an appetite for celebrity scandal, but that's not the same as the public interest. I believe that it would be the conclusion of any reasonable person, and that includes investigators. But the question for professional investigators, who are for the most part acting for commercial interests and not the public interest, is that there at any time it can be deemed, is there any time at which it can be deemed acceptable to obtain personal information by deception? According to my understanding of the Data Protection Act, it may be. The Data Protection Act provides a defense if the person transgressing the act has done so for purposes of detecting or preventing crime. There is no reason why that defense should not apply to journalists, to investigators, or for that matter, any member of the public. For the defense to be effective, we believe that it would be necessary to demonstrate that there was reasonable cause to believe that there is a crime to prevent or detect. In other words, you can't contravene the law on a whim or because you think there might have been a crime committed. You have to have some information that a reasonable person would consider reliable that would lead you to believe that there could be a crime. There's currently a case now involving the rival bids of West Ham and Tottenham Hotspur for the Olympic Stadium after the Olympics. The allegation is that West Ham, which won the bid, paid £20,000 to an executive of the group that made the decision. According to the Sunday Times, the relevant bank and telephone records were obtained by investigators hired by Tottenham. If the obtaining of the information becomes an issue in the case, and I suspect that's likely, then it may for the first time test the DPA defense that I was just talking about. Now, in my own business, I require that we pass what I call the front page test. If an action that we're considering were to appear on the front page of a newspaper, could we defend it as reasonable? If there's any doubt, we don't do it. But once again, there's a larger issue here, and that has to do with the access to information. To put in the terms of one of my colleagues, information is like drugs. Provided you know where to go, you can buy anything. That was also pointed out today in The Guardian, in a very good piece by Heather Brooks, who is the campaigner responsible for making MPs' expenses a matter of public record. The reason there is a market in such information is that too much information that should be in the public domain is not. I agree with Heather when she says that the way to stop this black market trade in official information is not to further criminalize data, but to make it public. We all pay for the justice system, so for example, Why shouldn't criminal records be a matter of public record? And the same applies to documents generally. I'll stop my speech there.
Katz, what about schizophrenic law?
Tell me about it. I better just declare an interest in all this, because as a media barrister paid by the case, I act for all the national media organisations in this country, highbrow and lowbrow, and it certainly gives one a good overview of how different journalists work and different media organisations work, and importantly, how different media organisations and different journalists have dramatically different views about what is and is not in the public interest, which is the issue, in a sense, at the heart of this debate. And can I also, in consequence of this, when I speak about the public interest, you need to understand I'm a real expert on that topic as far as media law is concerned. Last week I spent a day cross-examining Rio Ferdinand about his sex life. I did so in defence of the public interest. It wasn't so much the front page test as the back page to the front page test in that case. I declare a disinterest as well. Obviously I'm not a journalist, so one side of this debate, which is the ethical side, is not really for me to talk about, save to the extent that, as David will know, increasingly ethical issues and issues about the responsibility of journalistic behaviour are seeping into legal decisions that are taken by the courts for various reasons, and I'll explain that. So we have to become experts in the PCC code and the ethical issues, not from the perspective of a practicing journalist, but from the perspective of how judges might react to freedom of speech arguments on behalf of journalists and lawyers in light of how the conduct concerned plays out in relation to the PCC code. Of course, I have my own set of ethical obligations as a lawyer, which it means that I can do this sort of thing. I can advise media organisations about the public interest arguments that may be available to them under the DPA if they buy the disc from the source, setting out all the MP's transgressions, and then I can go off and defend the MPs who feel their expenses. Not very successfully, I have to tell you, but that's what happens when you do things on a case-by-case basis. The interesting thing, I think, about the ethical code from the point of view of what's gone on here is that there is a fleeting reference, although only a fleeting reference, to the position of agents or intermediaries in the code. It doesn't deal expressly with the trend that's become apparent from some of the recent disclosures of the journalists taking the story, in effect, or the material from a private investigator, and thereby, as some may like to have it, alienating their ethical responsibility one step down the line, and perhaps wanting to be able to argue, well, the source was the private investigator, we took the material from the source. It's not for us to investigate whether the source, the private investigator, has conducted him or herself ethically as if they were a journalist. Now, the problem is that doesn't work under the code, because the code is quite clear. Under paragraph 10, clandestine devices and subterfuge, the justification of the public interest must come through the media organisation and the editor in relation to the whole exercise, because it says engaging in misrepresentation or subterfuge, including by agents or intermediaries. So in fact, under the code, the editor and the journalist who takes the story is responsible for checking out the ethics of the private investigator and so on and so forth. So it doesn't work, basically. To the extent they're trying to do that, it doesn't work. The legal position is defined now both in domestic law and conventional human rights law, as I'm sure you all know. This is interesting because the historical position in this country has been, prior to the Human Rights Act, that you can do anything that's not unlawful. You have small categories of unlawful behaviour, like libelling somebody or breaching copyright, not previously interfering with privacy. And you can do anything else and write anything else provided it's not unlawful in one of those senses. And there were occasional examples in the past of journalists getting done for trespass offences, occasionally even burglary in the public interest that I've been involved in. Well, I mean, you laugh about it, but my old friend Jerry Gable of Searchlight once stood outside a well-known fascist's door, doorstepping him, and a British gas man came by and dropped his pass, allegedly. Jerry became the gas man, got into his flat, rifled through his papers, and got prosecuted for burglary because he did some criminal damage in the process of doing that. And of course, there's no public interest defence to burglary, but this sort of stuff is
unless you're MI6.
Unless you're MI6, that's right. But I mean, we all think what he did was in the public interest because he actually found out. This was David Irving. He found such very interesting information in the papers in David Irving's desk. But he proudly has a conviction for burglary. I know because I've called him as a witness and I had to disclose it. But so it has happened, but on a very small scale. I think these guys would agree in the past. So we've been relatively free of regulation, industry regulation or legal regulation for many years in the newspapers in this country, really to the last 10 years. Under the European Convention, Article 10, you can do anything, presumptively, again, which is journalistic activity, part of your freedom of expression right. And any interference with that has to be justified by the state on a case-by-case basis as meeting some legitimate aim and being a proportionate interference on the facts of the case. The interesting thing under Article 10 is that it's the only human right in the Convention which you have to exercise responsibly. Freedom of expression. You don't have to exercise your right not to be tortured responsibly. You don't have to exercise your privacy rights responsibly. You don't have to exercise your rights of freedom of association with others responsibly. But for some strange reason, the drafters of the Convention put an obligation to exercise the freedom of expression right responsibly actually in Article 10.1. And this has become very material to the law of freedom of expression in Europe, because when courts in Europe and now here do that case-by-case balancing exercise about whether the intrusion on the activities of the journalist, publishing or investigatory, is justified, they weigh in the balance the extent to which the journalist has behaved, quote, responsibly. That has become a big issue, in particular in this area where there are intrusions into privacy, because of course judges who want to put the boot in on the press seize on the obligation to act responsibility and use it as a kind of an extra weapon in their armoury to do down the media and the journalists. One of the interesting aspects of the Human Rights Act, as I said right at the beginning, is that Section 12 feeds in the Privacy Code and the conduct of the journalist under the Privacy Code into a lot of legal adjudications on freedom of expression issues. It is, the bottom line under Article 10 is there is nothing in the human rights law that says you can't commit a wrong, civil wrong, or a crime in the exercise of your freedom of expression right. It may be justifiable for the state to prosecute you for that, or for you to be pursued in privacy proceedings or so on and so forth, but it's always a question of fact to be judged on the basis of the facts of the case. And there is always, therefore, under Article 10, the possibility of a public interest defence or some overriding reason for behaving unlawfully on the part of the journalist to avoid the legal liability. One of the things that concerns me about all this is that in the last 10 years, and I'm not speaking about hacking, I'm speaking about where we are now with the hacking scandal going on against the backdrop of what's happened over the last 10 years, is that partly, unfortunately, as a result of that convention case law, as we all know, and the introduction of Article 8 and privacy rights onto the legal scene, the largely unregulated terrain in which the journalist used to operate, both in terms of industry regulation and law, has become much more crowded in the last 10 years. Obviously, the development of privacy has been a big intrusion into press freedom. You may think it's justifiable, you may not. It depends on the facts of the case. But it is a new potential limitation on the landscape that we simply never had in our law in this country until 10 years ago. It has spawned the judicial freedom to grant prior restraint injunctions, which we never allowed before in this country, in defamation or for any other form of expression, except in exceptional cases. They're now granted like confetti, and it is a very worrying tendency that something that is regarded as such a drastic interference with freedom of speech, in effect, pre-publication censorship, is now available to judges as a tool to use against the press. I'm not alleging any bad faith against any judges or anybody in particular, but there is a tendency when you give the courts and judges a new toy for them to play with it, a new tool for them to play with it. And things that were regarded as virtually unconstitutional in this country before, the prior restraint injunction, suddenly becomes a day-to-day routine thing for judges. And it strays into, and I know David's very concerned about this, defamation and other areas, because judges get so used to granting prior restraint injunctions where they never did before. There's been an increasing recent use by the prosecuting authorities of misconduct in public office offences to pursue sources and journalists who might know who the sources are, who collude with them. The offences under REPA obviously are an example of that. It's strange and perhaps slightly ironic that REPA was introduced to control state interception, primarily to control and regulate state interferences with the Article 8 right of privacy. And it's ironic that the journalists who are being charged now, or will be charged with offences under REPA. Then there is corrupting public officials before the 1st of January. Now, even more worryingly, the Bribery Act after the 1st of July, which is a terrible, from journalists, it's a terrible piece of legislation because it contains no whiff of a public interest journalistic activity defence in relation to bribery. And bribery is very widely defined in the Act. So there are all these things going on that are new to us and alien to us. And although the principle is still you can do it unless you're prohibited, there are more and more prohibitions on the scene. And what worries me in this in this terrain is that we now have coming onto the scene a major scandal about the way some journalists behave, and it is only one section, as David says, of the journalistic community, and it enables the politicians and the judges to justify their increasing intervention and possibly justify further legal and regulatory intervention into the profession. And I regard that as a very worrying tendency, that public interest judgments, the risk is, will be taken increasingly away from editors because of the malpractice of some editors and journalists, and given to judges who we have wonderful judiciary in this country, very highly skilled, very honourable, but they aren't journalists, and their ability to wrestle with arguments about responsible journalists and public interest is necessarily limited. And thus far, they have not shown themselves to be good at it. In fact, a lot of them equate responsible journalism with the negligence standard, which is just a natural tendency for a lawyer in this country, but is really not appropriate at all. So we have now a judicial inquiry by a judge who is an expert in criminal law and many other areas of the law, but is not an expert in journalistic practice. And the tendency in these situations with these public inquiries, we know, is to produce recommendations that are for legislation or greater regulation. It's what happens in every public inquiry. And so, like David, when he says it scares me a little, it scares me a lot, actually, not just a little. And I do think he's right that prosecutions of criminal offences is a better way. And to come back to where I started, you only have to look at what happened with the MPs and how the auditing of their allowance claims since the prosecutions has shown them bending over backwards to behave transparently and reasonably and properly in relation to their allowances, because they saw a few of their colleagues get 18 months in prison. And I'm sure this would have a salutary effect on the journalistic profession if it happened to them as well. And it is a corrective mechanism that doesn't involve politicians and judges crawling all over the profession and trying to make judgments about what should and shouldn't be the ground rules when they're really not, I don't think, qualified to do it.
Good, thanks. But Jeff, let me ask a question if I may. I mean, one of the extraordinary facts that's emerged is the sheer, I think the phrase, industrial quantity of bugging operations that's going on. How does that happen?
Well, I mean, the figure that's been bandied about is that they reckon there may have been 4,000 people who were hacked, or who were potential subjects for hacking. We don't actually know yet how many people were actually hacked. It doesn't take, first of all, it doesn't take a lot to hack a phone, number one, if you don't change your PIN number. And number two, it doesn't take a lot of people to hack 4,000 phones. I mean, I suppose if you spent your day doing it, you could probably hack, 50 phones in a day. So it's not impossible for that to happen. And as I say, I think, I have to say, I personally was surprised by the scale of it. I wouldn't have imagined it to be that big. I mean, I had no doubt that that sort of thing goes on because, as I said earlier, if something can be done, it will be done. But I have to say I was quite surprised by the scale of it. What I wonder is how many journalists were involved and how many investigators were involved. And I suspect you'll find a far larger number of journalists than investigators.
Mm-hmm. But I mean, one of the questions that emerged out of that, I promise not to go further with this, but because the actual ethical and political issues are much more important in a way to this. But one of the curious things that's come out was that a significant number of royals and other immensely important and powerful people, their phones were hacked. And I would have assumed that the security services would have had responsibility for the security of their phone.
That's a fair assumption.
And yet that these were precisely the phones that were hacked.
Yeah, I mean, I think that if people are newsworthy in the eyes of the tabloids will approach them in the way that they think is necessary to get the stories that they feel they want. And if there are people out there who have the ability to do these things, then they will employ them to do that. As I say, information is like drugs. You can buy anything you want, providing you know where to go. And that's not going to change. What will change, perhaps, is the readiness of particularly journalists in this case to employ those methods.
What's the argument about editor responsibility? Because if in fact the editor is ultimately responsible for what the troops do, then the editors would be criminally culpable, wouldn't they?
Well, the editor's legally responsible. Rebecca Brooks was legally responsible for the Millar hacking, even if she claims, although she has not yet actually managed to claim it publicly, she was on holiday at the time.
One of the problems in this area of law for journalists is that there is a strand in the law which we push all the time, which has some legs with some judges and has been the subject of some very high judicial authority in this country, which is judges in different areas of journalistic activity and expression have to give a margin of appreciation to the journalist and the media organisation because they are the professionals and they will exercise their judgment. And the paradigm example of that is the editor, who you will say on behalf of the media organisation should be allowed latitude to reach a judgment about what should be in an article, what should be investigated in the public interest and how it should be investigated. The problem with that is, and it's very good strand in the law, the problem with that is there is a quid pro quo in the eyes of the judges. And that argument will go down the toilet very quickly if they start to get the impression that editors aren't really these responsible, overseeing, semi-auditing characters in the exercise that they have been led to believe they were, that they're in fact operating without any real ethical standard. So there is a real benefit to be had through being able to demonstrate that the editor has a hands-on role in auditing the practices of the journalists in the media.
In relation to that, one thing which has thoroughly amazed me, I go back to Rebecca Brooks' appearance before the committee in, I think it was 2003, when she was directly asked, have you ever paid police for information? And she said categorically yes, before Mr. Coulson was able to step in. Now that was back in 2003 and nobody seemed to raise an eyebrow.
Even though it's demonstrably illegal.
Absolutely, and the other thing about it, of course, is that it obviously didn't stop there.
We could actually open it up for discussion if you like. Oh, hands up. All right, go ahead.
Gavin's point about prosecution rather than regulation being the answer, I'm sure is correct. The senior politicians seem to be determined to go down the regulatory route, however. I mean, it seems to be that the two models that they have to look at, Ofcom, in which case all media organisations would have to come under it for it to work, or alternatively you regulate journalists, the BMA, GMC, Law Society, Bar Council model, is unworkable. What model are we going to end up with if we don't do that together?
Well, it's very worrying that the reaction of the David Cameron and the government should be to try and push this in the direction of talking about the need for more regulation of the press. And this is why I say you should put the malefactors in jail who've broken existing laws. And I don't want us to have an inquiry in which we're all summoned, compelled under oath and cross-questioned about whatever grubby things we may or may not have done. And at the end of it, there's a report that says we must have either statutory regulation or some kind of draconian regulation. So the problem is, first of all, the News of the World, the Murdoch Empire has to clean up its act. But secondly, the self-regulators, the PCC, that has to clean up their act, which involves scrapping the PCC, throwing Lady Peter Buscombe off a cliff, and trying to construct a self-regulatory body which is not just going to be a corrupt, captured tool of the tabloid press, but is going to be able to throw its weight about and command respect. That's the only way to save us from the bad things, I think.
I mean, there is a fundamental problem in regulating journalists as you regulate the other professions you mentioned, which is that journalists are like terrorists, right? They're quite right. There is no acceptable or settled legal definition of what a terrorist is, and there is no equally acceptable, settled definition of what a journalist is, who would be subject to the regulation. It is even more nebulous now than it was 20, 30 years ago. But there isn't a single channel of qualification which enables you to say that person with that certificate is a journalist. So that's a big problem. The regulation of the statutory regulation of broadcasting through Ofcom has always been justified and justifiable because of the recognition in media law and freedom of expression law that the broadcasting media has a greater impact than the print media and has greater potential to cause harm. That's the cover for doing it, and there are European standards about that and recognition of that, and you can have better or worse broadcasting regulators. I won't say what I think about Ofcom. There's some good, there's some bad, but it should be light touch, to use David Millar's words when he brought in the 1996 Broadcasting Act. That sort of regulation should be light touch, and it should be done by people who probably understand freedom of expression. But the problems are not the same for broadcasters as journalists. It's a very different medium. And I don't know. I mean, I do go around the world, quite in Europe in particular, to look at other countries and how they regulate or fail to regulate the print media. And there really aren't, I don't know any satisfactory examples of statutory regulation of the print media that don't lead to Article 10 problems, because it's the state intervening and often chilling freedom of expression by the mere fact of the state regulation. You know, as for industry regulation, well, the industry is clearly not working across it to exactly the same standards, which is why ultimately I think the responsible editor is the best regulator. The internal responsible editor is the best regulator. But there's a risk of losing that benefit.
Well, I mean, I'd like to see in the medium term some kind of set of guidelines from a reform PCC, as I say, about the use of private investigators, and I think that would address a lot of these problems. In the slightly longer term, it all becomes irrelevant because of the corrosive effect of the internet. There isn't going to be any newspaper industry in 10 years.
So that's the third reason why you can't do it. What are you going to be regulating?
Yeah, I mean, 2 points. One, your point about the security services securing the numbers of the princes and what have you. I mean, the real double whammy of News International was A, to use private investigators to get numbers, B, if and when they couldn't, or in tangent with it, they bribed the police officers, the Royal Protection Police. So if you didn't get it with A, you got it with B. And that is, I couldn't give a monkey's about the prince, but it is a serious criminal offence, clear, very clear. But I think one aspect which the panel hasn't touched on is the increasing competition urgency between newspapers and the net and what have you. So that what has happened is that this started in a very small basis. One person may have done it. But virtually every newsroom, and I exempt The Guardian from it and probably the Financial Times, but virtually every other newsroom in Fleet Street has used these methods because the opposition is using it. They are using these methods to get the story, therefore they get ahead. They get the story 24 hours before the other one. And that 24 hours in the modern media world is everything. So the Millie Dowler thing, and what happens with a guy like Glenn Mulcahy? He just gets given a long list of numbers. He doesn't get told Millie Dowler, Gavin McFadden, David Leigh, just get all these numbers and do that. And to him it's a job. It's a risk and he's been to prison, but he made a lot of money. But what has happened is that in certain newsrooms, using these methods has become the default method.
Yes. That's right.
And that is the real cancer, because it will mean a sacking of quite a large number of journalists and a large number of criminal cases. And I think, you know, we have to accept that the cancer is bitten deep in the whole methodology of British journalists. I can't speak for other countries, but as I say, in some newsrooms, as soon as a story comes in, a tip, a hint, shall we give it to see what we can get? And what it is now is a fishing expedition. They don't even know what they're going to get. They just say, well, let's see. Let's use the illegal methods or the private investigator to do it, and let's see what it comes up with. It's very, very difficult to stop that.
Except that one is reminded of the points that Jeff Katz made earlier, that it's not just the newspapers.
Sure.
And you have a culture now with this internal contradiction, where, what you pointed out, I thought rather well, that we just accept the fact that a huge element of the state can survey anything it wants with complete impunity. And yet, if journalists do it, there's a big problem.
But the problem is that we have to clean up our act before you can take a campaigning stance about surveillance by the state. That's the problem at the moment. The industry has such dirty hands that, you know, it's not easy to campaign on it.
True. Back.
I'm going to ask a deliberately provocative question, okay? But I'm just curious here, okay? The Daily Telegraph paid £100,000 plus, I believe, for the expense records of the MPs that, you know, earned them $1 million+ circulation over the month. Great story. Heather had a great role in it as well. But I'm just curious, you know, if you know, are you concerned that the coming wave of regulation is going to make that kind of deal illegal as well? And if David, you know, if you were in a court, I mean, I don't know if the Guardian would pay that kind of money to have such records. Would you? And well,
There's a terrific paradox about all that, because I just know that the guy. I thank God, David, that we were never offered them. So we never had the anguish of the decision, because I know that the Guardian would never have done that. We would have said, we're not going to pay £100,000 to buy stolen documents. You must be crazy. And yet, when the Telegraph did it, we could see they did the right thing. They made the right call. Excruciatingly difficult. As for the question about illegality, I think what happened there was what the Telegraph did was probably illegal in some ways, but it's not in the public interest, and the prosecution authorities see that tacitly to prosecute them.
Well, that's exactly what happened though. It was a DPA offence. I advised certain media organisations. The pragmatic advice that they were given was you won't get prosecuted for this, provided the material you run isn't problematic from Article 8 privacy point of view. It isn't people touch on their medical records or anything like that. Because A, you're investigating the establishment, and it would be embarrassing, and B, the second limb of the prosecutor's test for instigating a prosecution, beyond is there a reasonable prospect for conviction, is the prosecution in the public interest. And it didn't seem to me likely that the DPP at the time would authorise that sort of prosecution. But I mean, the underlying question is, you know, in the absence of a distinct defence in the DPA, just as there isn't in the Bribery Act, do journalists and editors at certain points say, we will be prepared to do things that are unlawful and criminal in the public interest? And I do go back to what I said at the beginning. I wouldn't like to see the baby thrown out with the bathwater over this whole episode, because it is the case that you can, if the public interest is great enough and the investigative technique is limited enough, you can justify even committing criminal acts in order to pursue investigative journalism and publish stories.
Well,
and if the climate, yes, I mean, I was saying to Gavin before, the problem is that the public interest bar has been set so low in the minds of politicians, you know, as operated by the media, because of where the tabloids set it, that it is very difficult to get anyone to concentrate on higher public interest arguments and what might be justifiable but unlawful investigative techniques, where that is what is at stake. And I do think there is a risk that you give it over to Lord Justice Leveson or another judge to look at. They will draw the line at anything illegal, and they will fail to see the argument under Article 10 that can justify unlawful action in the public interest.
I mean, I think that the issue here is judgment, and I think that's the point. And the point that Martin was making earlier is that judgment has gone out the window. It became automatic, and so there was no individual judgment case by case, which is what you would expect from somebody who is exercising that sort of discretion.
Yeah, I just wanted to comment on what you're mentioning regarding GCHQ and how there is a state surveillance. But rather than hang ourselves in the moral repugnancy of certain aspects of the test, how about using this as an opportunity to widen the discussion into why are we allowing telecoms providers to spy on everybody always for free? Why are we allowing all of these social media services to do the same? Why are we allowing companies such as Apple, Google, etc. to do massive, large-scale, essentially just espionage on everybody? So, I mean, there is the press factor in this, but there's also the other factor, which is just that the surveillance society that we're living in, it isn't just the press and the state, it's also all of the companies that have any vested interest in gathering, collecting and disseminating information.
I think it's a good point. I think as was said earlier, the problem is that right now this has got the profile, and I think from a journalist's point of view, the sails have to be cleaned before they can take the high moral ground and say, look, all these things need to be dealt with. But I think you're absolutely right. I think these things do have to be dealt with, and that by and large, this situation has emerged the way it has because the politicians have absolutely loved it. I mean, it's just a wonderful opportunity to make the press the whipping boy. And the problem with that, again, as David says, is that you've got different sectors of the journalistic community, but that distinction isn't being made in what's being talked about now.
I mean, I want the press to be effectively regulated. I long for it, because then we would have the moral high ground, and then we could do something about the rest of the state of society.
But would you trust the state to do the regulation?
No, of course not.
Okay, fine.
Yes, Mark Watts. I share Gavin's concerns, expressed deep concern about statutory regulation of our industry. And I just want to say something about the two categories of Jeff's industry that he talked about. The dodgy end, shall we say, of the private investigations industry, where they're acting for large corporates on a smaller scale. In case anyone's forgotten, it isn't only journalists and newspapers who employ these people to form, shall we say, the dark arts. For example, your profession, Gavin, I'm not mentioning you specifically, but certainly many solicitor firms use the same sorts of firms to do the same sorts of things. And as I understand it, that industry, that profession is regulated. I think the issue about whether we should have statutory regulation is completely missing the point that there is statutory regulation for this kind of thing. It's the law. And asking PI firms to perform these dark arts is simply breaking the law, and as I understand it, driving a police officer is too.
Yeah, can I just make a comment about that as well? I think I entirely agree. I think if there are businesses that, well, give an example. I mean, we get instructed by law firms frequently, and I do occasionally, and usually it's from quite a junior trainee lawyer very often, who's been instructed by a partner who says, "Oh, go out and get me a quote for getting a bank account about this chap." And I get an email, actually, from a major city law firm, a trainee, of course, because he doesn't know any better, saying, "Can you please tell me how much it would cost to get into the bank account of Mr. So-and-so or company so-and-so?" And I write back and I say, "You do realize this is entirely legal and something you would never do, and you shouldn't really be asking me." And that's happening, I have to say, a bit less frequently now than it did maybe 2-3 years ago. People become a bit more aware of data protection. But it does happen, and certainly we turn cases away where we feel we cannot justify it. Now, there might be cases, and this goes back to what Gavin was saying earlier, where we think we are in a position of perhaps detecting or preventing a crime, which would be theoretically defensible, and so we may take the risk in a given case if we think it's justifiable. But to be fair, that case is not yet, that issue has not really been tested, and frankly, I would like to be the test case.
Well, can I just clear this up? I mean, Gavin, I'm sure you know, the test is a bit wider than that under the DPA. Don't we have a public interest defence?
For journalists.
For journalists. But if you're acting for a journalist, which is this audience, you would be able to avail yourself of the same public interest.
Maybe.
You wouldn't have to go down the preventing crime route.
Maybe.
Maybe. Want some free legal advice from Gavin.
One last question, Raj.
I was going to say, once the heat dies down, I'll bring you back to normal, because only a tiny fraction of criminal cases get investigated, let alone get prosecuted. So it's all fashionable at the moment. But a couple 2 years in, regardless of whether it's self-regulation or statutory regulation, no one's actually going to prosecute.
It's true. It is true. I mean, there's a resources issue there. They couldn't prosecute all the tabloid journalists they would need to prosecute to do the job properly, just as they couldn't prosecute all the MPs they needed to prosecute to do the job properly. So they picked out a few choice cases, did them in terrorem, and hoped the others would be sufficiently frightened to just stop doing what they were doing. But, I mean, the amount of police time and effort that would be involved in potting all of the journalists and all the private investigators who've been involved in this would mean that, the streets criminals would be walking in the streets for the next 10 years.
All you need is to put James Murdoch in jail. That will do the trick.
Thank you very much.